rise. The Court of Appeals Division 1 is now in session.
Thanks. Please be seated. Good morning, everyone. We're here in oral arguments on Power Global Trading Company versus John G. Grdina et al. CV210475. As you know, we're live streaming and recording these proceedings, so please give your name and your client's name before you begin. You're going to each be arguing at your own podium this morning, and you have 20 minutes, which is reflected on the clock. We ask that you keep your own time, and the clocks will reflect the time you have remaining, including whatever time you'd like to reserve. Keep in mind we have read the briefs, studied the record, and discussed the case in conference. And with that said, counsel, you can proceed.
Thank you, Your Honor. Matthew Hoxie, on behalf of appellants, Gen Life, Mr. Grdina, and Mrs. Grdina, I'd like to reserve roughly 5 minutes of my time for rebuttal. The Superior Court denied my clients the ability to defend themselves on the merits against a $620,000 default judgment when they were never served. In denying the motion to set aside, the court ignored 3 key principles guiding this case. The first, the law favors resolution on the merits. Second, any questions or doubts should be resolved in favor of setting aside the default judgment. Third, matters involving large sums should not be decided by default judgment if it can reasonably be avoided. The court ignored these principles and incorrectly determined that my clients did not meet the requirements to set aside the default judgment when they were never served and did not receive a copy of the complaint and summons that was purportedly left at their house. Instead, the court accepted the claims of the process server, which contained inaccuracies and changed over time. My client identified those inaccuracies in his declaration and explained that he lives with his wife and children and has no roommate, a man whose identity remains a mystery to this day.
Counsel, the inaccuracies are that your client didn't have a roommate and that the child was on a scooter versus that detail not given. Is that the main discrepancies you're referring to?
Correct, Your Honor. Those are the 2 main, but I would say probably first and foremost, besides those 2, is that he never encountered the process server in the first place. So never encountered the process server, never received service, has no roommate, no roommate resides in the guest house on the property. That was a fact added in the second statement by the process server. My client submitted a second declaration again stating he never received service, never encountered the individual, and the guest house has no tenant.
But there was no argument that the process server went to the wrong house, right?
I believe that's correct, Your Honor.
Okay. And I'm having difficulty seeing what the significance is of this individual's status as a roommate. Why does it matter if there was a roommate or not?
That was a fact accounted by the process server. And
well, sure, but the process server could have said the house was blue when in fact it was gray. It just doesn't matter if it was the right house.
Well, I think it matters because it goes to the credibility of the process server's account and my client's statement that he never encountered the process server at his home and never received service. And without service, he had no duty to defend or weigh in this case.
Well, I understand the importance of service. I guess what I'm focusing on here is some unfortunate procedural realities of this case. When your client submitted a declaration suggesting that there had been either false statements or confusion in the process server's proof of service, there was never a request for an evidentiary hearing, which would have allowed testimony. Why is that?
Because to answer your question, Your Honor, my client was not required to request an evidentiary hearing. My client submitted a declaration clearly and unequivocally denying service. And when the credibility issue...
But doesn't he have a duty, though, to provide clear and convincing evidence to overcome the presumption of the process server's affidavit? And if that's the burden, clear and convincing evidence, does just a he said, she said ever get the court there to overcome that burden?
Well, I don't believe we have just here a he said, she said. We have the clear and unequivocal denial and the explanations of the inaccuracies in detail. And that's the convincing part of the clear and convincing standard. And it's no different than this court's resolution of similar motions to set aside in Union Oil Co., Rogers, City of Tucson, or Occidental. If plaintiff prevails in this matter, it's to lead to the result that any time there is a sort of dispute of this kind, the default judgment would never be set aside, if that was the standard. In Union Oil Co., the court set aside a default judgment where the defendant insurer did not receive mail, despite the statutory agent actually being served in that case. In Rogers, the court similarly set aside a default judgment for lack of service, stating it would have been an abuse of discretion not to set aside the judgment. And those two cases are important because they reaffirm the two principles, the first two principles discussed, that the law favors resolution on the merits and that any doubts or questions should be resolved in favor of setting aside the default judgment. There may be some contention between the clear and convincing standard on one hand and those principles, but those are the guiding principles this court relies on. Just as it did in Roe v. Yanka, in beginning its analysis, the court stated, several general broad presumptions are of important influence in this area, including, first, it is a desirable legal objective that a case be decided on the merits. Second, again, that on a motion to vacate a default, any doubt which may exist should be resolved in favor of the application. And it's not as if my client solely moved on the basis of lack of service. My client also moved on the basis of the large award. And
Well, let's stay on the lack of service there for a minute, because you say, well, what would happen if no one would ever get a default set aside? But what's the flip of that? Is that every time you just raised your hand and said, I'm filing an affidavit that I wasn't served, and that without an evidentiary hearing being requested or anything else, that the court, based on your principles, has to set every default aside because someone says, no, the car was black when you said it was blue. How are you reconciling those two things in the extreme?
By application of the case law as it exists, and I certainly understand the court's concern about opening the floodgates to any declaration that says, I did not receive service, period, full stop. But that's not what happened here. My client went further and explained he has no roommate. He's provided sort of the convincing arguments about why, and explaining the inaccuracies in the process server's account. And this case is easily distinguished from those relied upon by plaintiff, such as Security Trust or Duckstein. In Security Trust, it was solely defendant's belief, and that's a quote from the case, that he wasn't served. In Duckstein, the husband argued improper service based on a technicality that he claimed his signature was not affirmed in the presence of a notary. In General Electric, the defendant admitted her cook placed the summons and complaint in the mail, and she examined those. None of those cases change with this court granting relief in my client's favor and set aside the default judgment. Again, my client clearly, unequivocally denied service in two declarations and explained the changing story of the process server and the inaccuracies that they contained.
If I may, your client's declaration is a rather glancing challenge to the process server's proof of service. All it says is, I don't have a roommate. He doesn't say, I don't know anybody who drives a Cadillac. Nobody's allowed to just go in my house without being invited. A lot of the circumstances surrounding the proof of service here really go unchallenged when you take a close look at his affidavit. It's just the status as a roommate, which is a pretty amorphous standard. So I don't see why we should be so concerned with whether this individual is a roommate or not. It's more interesting to me whether he even knows anybody who could meet this description, and he has not challenged that. So how do we get to clear and convincing evidence from that?
Well, I believe that challenge is sort of subsumed when my client states he has no roommate.
It's hardly subsumed at all. I mean, I have friends who are able to enter my house, and I know what kind of car they drive, and I know what they look like. And whether they're roommates or not, I would be able to say, I don't know anybody who drives a pink Nash Rambler and is 6'7". Not only are they not my roommate, but I don't know that type of person or a person who fits that description. And here there's a pretty clear description of the individual, and there's no effort to disclaim knowledge of who that person is, only his status.
I appreciate Your Honor's concerns. I think that's a little over-exacting requirement for a party who is stating that they never received service.
It's not exacting at all when you're stuck with a over $500,000 judgment, and you think that a process server is making up a story out of whole cloth, it would seem that if you have a clear and convincing evidence burden, you would submit a declaration that just lays waste to the process server's statement, not nitpicks with it.
Your Honor, maybe it was, stating now, maybe it's better that he submitted a 20-page or 10-page declaration pointing out all those inaccuracies, but if there was any questions about going to the credibility of that declaration, that should have been resolved through an evidentiary hearing, which this court never held.
Why wasn't one asked for? Again, you have the burden. It's clear and convincing. There's a presumption that he was served. Why didn't you ask for an evidentiary hearing, either at the outset on reconsideration? Why are you suggesting, and under what authority would we say that where you have, and I'm going to say he should, she said, because we don't know. Nobody had an evidentiary hearing. One person said one thing, one person said another. Where are we to get the authority that we tell a superior court that every time someone raises their hand and says, I've got a detail in the process server's affidavit that I disagree with, that they have to set an evidentiary hearing without being asked to do so? What authority do we have? Where do you find that?
I would point the court to First American Title Insurance Code, as stated in our papers, where the court said a hearing should have been held to determine whether there was clear and convincing evidence to overcome the presumption.
Is that First American versus Martis?
Yes,
the
correct.
Unpublished opinion?
Yes, but...
Okay, in which case the title company actually knew because the client there had told him that he was moving to Florida. And after he moved to Florida and let them know, they ended up serving him back at the place in Phoenix where there was no evidence at all that he lived there. And that was a factual scenario. Does he actually live there? Could he have possibly have been served in Phoenix? So it seems distinguishable and is unpublished. I'm not sure that that's the authority that we say sua sponte court every time someone has a difference of opinion with an affidavit.
I'd also add that it was unpublished and issued before 2015.
Correct, Your Honor, but there is no other case in Arizona deciding the issue of whether or not the court should sua sponte hold an evidentiary hearing when a factual dispute arises or comes to a head in competing declarations submitted after we made our initial request.
But then if that's such a clear rule after 100-plus years of statehood, one would think that there would be such a case. I mean, you're suggesting that this rule is something that the trial court, I think your word was ignored, but we can't find any authority for it that's even citable.
Well, I pointed to First American. I would also raise Sanders v. Monsanto, which is a case out of the Fifth Circuit. Potentially the next best support is the case of Duckstein, where the court ruled that there should have been an evidentiary hearing. Granted, it was requested there. The court stated it was not explicitly addressing whether or not the court should sua sponte do it. But those three cases support that an evidentiary hearing should have been held to resolve these competing issues as raised by your honors in the declarations and the credibility determinations that accompany them. I don't know how the trial court made a credibility determination on who the he said, she said was correct.
I don't know the trial court thought it had to, because let's say that the fact is that this gentleman with the Cadillac is not your client's roommate. So what? Why do you need to make that distinction, that credibility determination? The real issue is whether your client was at his house and the process server went to the right house. It seems undisputed that the process server went to the right house. There's no indication that I saw as to whether your client was home at the time service was allegedly made, because the process server says he saw your client enter the house. So presumably if your client was gone, not at home, not at the place that we all agree he lives and the process server went, he would have said that. And that might generate a dispute. But the only credibility determination that I think you can challenge here, unless I'm missing something, is the fact that some gentleman who drives a Cadillac is your client's roommate. And that status is fundamentally irrelevant.
I disagree, Your Honor. But my client did not also state that he has no roommate. He stated he never encountered the process server. I think that also includes that to the simple fact, he never met the process server. So I don't know if the process server went to somebody else's house, was there on a day that my client was not there. In any event, that account or that event never occurred.
Your
And that's
client
what my
have any
client
friends
is
who
unequivocal.
drives Cadillacs? Because I don't see anything in the record disclaiming that, and that would seem to me low-hanging fruit if you wanted to generate a dispute of fact.
With due respect, Your Honor, I think the main contention is that he had no roommate and that he never encountered the process server. I understand Your Honor's concern with these other, what I would contend are more minimal
Well, if he
facts.
has a friend who meets the description, whether he's a roommate or not doesn't really seem to
And
get us anywhere.
I think
does it?
part of it is that if there was an adult that said he had some relationship with or ability to go into the home, be in the home for some period of time, come out of the home, that whether it's a roommate or a guest or someone who has access to the home, I think that's what we're stuck on, is whether he was a roommate or a guest or someone who had free access to be a roommate whenever he wanted to. The term roommate isn't as important as the fact of that there was an adult who said he knew your client, who was able to go into the house on request to get your client out of the house, who returned from being inside the house and said the client won't come out, and do what you want with the papers. So I think that's why we're stuck on the term roommate and whether that's important or not. When there are other facts there that show that he had access to the house, his status as a roommate isn't as important and wouldn't have violated service if he were just a house guest as opposed to a roommate.
Counsel, I know you'd indicated you wanted to reserve 5 minutes. You're welcome to do what you'd like, but I just know the time. With the questions, you're under 5 minutes now, so I just throw that out.
Thank you, Your Honor. And I understand Your Honor's concerns. And like I said, though, this is not the only basis, the lack of service, upon which we moved to set aside the default judgment. We also moved because of the large award, particularly in relation to the claims raised in this case and the meritorious defenses my clients presented. And I point the court to just 3 cases in which the large award, or cases supporting that. First, Roe v. Yanka, the court set aside a default judgment stating matters involving large sums should not be determined by default judgment if it can reasonably be avoided. In Gonzalez v. Wen, the court similarly set aside a default judgment when the pain and suffering award appeared excessive in relation to the claims.
I don't want you to waste your time, but I also want to know the difference between having a liquidated claim and an unliquidated claim and the effect that that has on the court's pronouncements in the cases you're giving us about whether a large judgment is the thing that we kick out because we don't like to see large judgments in default.
Sorry, can you restate that?
Just saying the difference in those cases of unliquidated and liquidated damages. Here we have invoices that show exactly what the costs were as opposed to a pain and suffering when someone stubbed their toe at a supermarket.
Well, to answer your question, I don't think there's a difference. Here we have invoices between Gen Life, a company, and Power Global, another company. It's a breach of contract case. My clients, Mr. and Mrs. Grdina, personally should have no basis for being in this lawsuit. We've raised defenses as to the fraud and misrepresentation claims. They're barred by the economic loss rule. And as to the invoices, my client in his declaration stated he repeatedly informed Power Global that time was of the essence as to the deliveries. And that element, when it was breached, is a breach preventing the then following performance by my client. And so those are the meritorious defenses. And I will just say that I don't believe the Superior Court took any issue with the meritorious defenses raised. It's not addressed in the court's 3-sentence, roughly, decision in this issue.
Okay.
With that, I'll save the rest of my time for rebuttal. Thank you.
All right, thank you.
Good morning. Brendan Murphy for Power Global Trading Company Limited. I want to take the opportunity to address a few of the issues raised by defendant appellant's counsel and also address some of the issues raised by the panel. The proof of service under the case law, there is a presumption that service is valid and can only be defeated by clear and convincing evidence. And that's General Electric v. Osterkamp, 172 Arizona 191. The only evidence in the declarations submitted on the briefing on the Rule 60 motion was merely that Mr. Grdina did not encounter a process server. And so you have a detailed proof of service describing events leading up to Mr. Grdina walking into the house after being told, I have legal papers for you, acknowledging a salutation, hi, Jay, hi, I have legal documents for you, walks into the house, never to return. The only evidence is I didn't encounter the process server.
Counsel, let me ask you this.
Sure.
Is it fair to say that the far better practice, where you have affidavits that are completely opposite, would be for the court to hold an evidentiary hearing?
So I would say that the rules of civil procedure provide the court with the discretion to hold an evidentiary hearing, hold oral argument, or not, depending upon the evidence that's before the court. So Rule 43, oh, I'm sorry.
Go ahead, which rule are
Rule 43F, Your Honor. Bumping into this microphone. So Rule 43F says, quote, if a motion relies on facts outside of the record, the court may decide the matter on affidavits or on oral testimony or deposition testimony. Now, Rule 43F, and I know that there's been over the years, does shall mean you must do it? Does may mean in certain circumstances you must do it? The amendments to the civil rules changed shall to must. And if you look at Rule 43, there are instances where the court or parties must do something. And within that same rule, you have Rule 43F that says the court may decide the matter on the papers, which is what happened here. Excuse me.
That's it's a good find, and I take you I take your argument seriously, reading the language of the rule. But it's also, I say as somebody who participated in the drafting of these rules, kind of a problem in the rules themselves, because as broadly as you read Rule 43F, it would seem to completely subsume Rule 56 and say that the trial courts can simply resolve cases on affidavits when you have a motion for summary judgment. And we know that that's absolutely not true.
Well, certainly on rules, on motions for summary judgment, if there are disputed material facts, that case is going to trial.
Right, but I guess my question is, Rule 43F as written would seem to say, well, court, you can just go ahead and resolve this on affidavits, because you may, and we'll save the expense of a trial. We know that's not the law.
I don't believe, and I'm not putting my hands on it, that Rule 56 is subsumed within 43F.
Well, it's clearly not. We have an abundant body of law in Rule 56. It's the bread and butter of civil practice these days, and we know that a dispute of fact is enough to forestall summary judgment. But read literally, Rule 43F would seem to drive a hole through that. So I'm trying to find where Rule 43F fits into the overall scheme.
Right, and I wish I were a civil rules scholar. I am not. All I am prepared to discuss, Your Honor, is the implications for Rule 43F in this case. And in this case, the 43F permitted the commissioner, the trial court, to rule based on the papers, and when read in conjunction with the Duckstein case, which is, as far as I can see, the only case that deals with the issue of when is an evidentiary hearing required in this setting, when there are disputed facts about service. That case, in a footnote, says we don't deal with whether or not a court is required to sua sponte order an evidentiary hearing. It's footnote 6 in the Duckstein case. And so the only thing we're left with is 43F, which 43F permits the trial court.
Do you think that it's significant at all that 43F is in the section of the rules relating to trials? And this was not a trial?
Well, Your Honor, it may well be significant.
I mean, I'm truly trying to figure out what the draft, I didn't take part in 43F, but what the drafters meant in 43F. And it would seem to me that the rule itself would make a lot more sense if it takes place in the context of a trial than just simply applying to any motion. One would think that the drafters would have put that in the section of the rules on motions.
That may make more sense, but I would also say that Rule 7.1 deals with motions and does not require that a court hold an oral argument. It's not obligated to make an order requiring a hearing generally, which may include an evidentiary hearing on a motion such as this that may have disputed facts. So you could read 43F, you could read 7.1C1 to support the trial court's view that it did not need an evidentiary hearing, or certainly did not need an evidentiary hearing because one was not requested.
But 7.1 doesn't actually deal with evidentiary hearings.
Correct. It deals with hearings on motions.
Right, or legal arguments like the ones we're having now.
And that's not clear to me, again, not a civil rules scholar, but it's not clear to me that hearings could not be broadly construed as evidentiary hearings and or requests for oral argument. Certainly, there was oral argument requested in this case. Only oral argument requested. Courts are not required to hold oral argument unless they deem it necessary. And certainly during oral argument, evidence isn't taken. But that rule talks about hearings, and so I don't know if you would subsume within it an evidentiary hearing on matters that are raised through affidavit testimony.
So, counsel, your take on Duckstein?
Yes, Your Honor.
Let's just say that instead of oral argument, let's say evidentiary hearing had been requested. And let's say the Superior Court granted default based on the affidavits. Would that have constituted an abuse of discretion?
Let me make sure I understand your question. Defendants at the trial court level requested an evidentiary hearing. I think that a fair reading of Duckstein would be if defendants requested an evidentiary hearing and one was not given. Duckstein seems to suggest you have to hold the evidentiary hearing, but there wasn't an evidentiary hearing requested here, only oral argument.
Thank you.
Okay. The other issue, while I still have some time, and I think Judge Bailey addressed it, but I want to be sure that there's no confusion, is the issue of this large amount of the award. Under the civil rules, when you have a sum certain, you could submit on the papers. There are invoices. It could be for $15 or $627,000 as we have here. The court can consider the papers, the invoices, and enter a judgment for the amount without holding a hearing to determine what the cases cited in the appellant's brief discuss, the nature and extent of an injury, the nature and extent of a broken leg.
And this is because you invoked the rule on liquidated claims.
Correct. And that was in the declaration submitted with the application for the default judgment. I also want to address this notion of changing stories. I would only note that, and it's in the papers, the roommate issue is really not, it's a fun fact that's included in the process server's initial proof of service. But what's important here, I think for purposes of the trial court's consideration of whether or not Mr. Grdina was served with papers, is that Mr. Grdina was out front, that Mr. Grdina responded to the process server when he said hello, used his name, told him that he had legal papers to serve him, and he turned around and he went back inside the house and didn't come out again. This is a memorandum decision decided in 2021, May of 2021. The Bank of America v. Cheeks case, recognize it's not exactly the same, but it's pretty similar, a pretty similar situation to what we have here. And I think an important point is, at least the Cheek case suggests, and I know that Judge Swan was on the panel, is you can't, this is just a classic avoidance of service situation, retreating to avoid service when you know the person in front of you is intending to serve process, has the papers in hand, and intends to serve you. So I just wanted to make that clarification, that the Cheek case, which under the Supreme Court Rule 111, this court can consider that case for persuasive authority, and I was unable to find any cases that deal with this sort of retreat situation in Arizona other than that case. And I will, unless the panel has any
I've got a
further
question.
questions,
Are you
please.
wrapping up? Is that what you're doing?
I think so.
Okay, I've got a question on, so grounds for relief. Rule 60B6 is the catch-all for any other reason justifying relief. What about the claim that's raised in the opening brief that with the default judgment, the Grdina's are personally on the hook for a $620,000 judgment when, as I understand reviewing the record, any contracts entered into were entered into by the LLC, not them personally. So why should that not be grounds for relief?
So the contracts, there are no written contracts. These are oral contracts with, and there's the allegations in the complaint are that Mr. Grdina ordered these masks personally. And I think it's important to note that he had these that he responded to requests and demands to make good on the invoices that were addressed to Mr. Grdina personally and also to GenLife. That he responded on his personal email and repeatedly said, yeah, let me grab it so I'm not misstating. You've got, I think it's at app 38 through 40, where Mr. Grdina acknowledges that the money, that he owes the money. I owe the money. He acknowledges he's working hard to get it paid off. I, not GenLife, there's no objection to him being pursued personally for this money. I'm going to sell Amazon stock. I'm going to get it paid. I'll get you a payment plan. And so, at least as alleged, and as we understood the case, he was buying it both personally and on behalf of GenLife. There are also allegations that GenLife is merely an alter ego of Mr. Grdina. It's not in this record, but that very well may be the case. It's alleged in the complaint that it is an alter ego of Mr. Grdina. But we have enough, I think, touch points in the record, particularly that he's accepting that he owes the money. He's saying I owe the money and is not saying I don't owe you anything. It's GenLife and GenLife's bankrupt. GenLife doesn't have anything. GenLife couldn't move these masks. No, he says I owe it, and I'm going to sell some Amazon stock to make that happen.
Thank you.
There are other questions from the bench. I will. Thank you.
Thank you.
All right, just a few points briefly. This is not a retreat case. My client never encountered the process server in the first instance, so that case cited by plaintiff is an opposite. The roommate piece is central to the story.
Well, what's the theory, though? Your client admits he lives there, doesn't say he wasn't at home at the time that service was purportedly made, and says he never encountered the process server and doesn't have a roommate. So is the theory that the process server is just lying, that the process server was never there, never saw him, never said hi, Jay? It's all just a fabrication out of whole cloth?
We don't know, Your Honor. The assertion is that it never occurred, and whether or not the process server went to a separate house at the time or something else happened, we don't know. Those are questions that would be properly asked during an evidentiary hearing. And, you know, as I believe Your Honor, Judge Swan noted, it's probably better practice to require an evidentiary hearing when such factual disputes that are central to a key issue here, such as service. Because without service, my client has no duty otherwise to defend, that it's better practice to hold an evidentiary hearing when something of that factual level is in dispute. And I would just note that the requirement for sort of point-by-point disagreeing with the process server's account, while maybe good practice, is not required by case law. And I would point this court to City of Tucson v. Melnikovich, in which the court set aside a default judgment where service was disputed or denied. And there the court actually took testimony, which is in keeping with Rule 43E. I know we've talked about 43F, but 43E, which evidences a preference for live testimony. The questions to the defendant there were, you're telling me that's not your handwriting and not your signature. That's right, not mine. You were living at 5008 East Speedway. This is in the case, so I'm not giving anything away. East Speedway, were you not? I did live there. The defendant there acknowledged he also lived there. You lived there on 5th of November, 1948. Yes, I lived there. Well, did you on November 5th, did you receive notice? No, you did not know. That was the extent. There was a clear denial, but there weren't other questions asked or other further statements disputing the potential process server account.
Do you have, and I know we're out of time, but do you have anything you'd like to say specifically on the interpretation of Rule 43F?
No, not at this time, Your Honor. And if I may have just 1 second to resolve sort of the liquidated damage piece, I think that goes to dispute between two companies. Again, there's no basis for my clients personally being involved in this lawsuit. That and the large damage award and meritorious defenses the court should set aside the default judgment in keeping with the three principles discussed today. Thank you.
Thank you. All right, the court will stand in recess and we'll reset for our next argument. Thank you.